Good morning, everyone.
Good morning.
We're so excited to have you here. This is part of our free legal seminar series. My name is Witzke, and I'm an attorney with the Disability Law Clinic at Witzke. We've done a 2-year fellowship now that provides free legal services over here at Carmanos Cancer Center. And I have some information about that program that I'm going to pass out. And one of the things that I wanted to let you know is we're recording this series today, which we're very excited about. And we will have some releases for you to sign if that is okay. And we're going to be bringing those in a second. But this will then allow us, for other people who couldn't attend today, to be able to watch this at a later date. Part of the work that we do is we've helped to give people information and represent them on issues around health insurance, employment issues, legal planning, advanced care planning, wills and trusts, and public benefits, how to attain them, how to retain them, how to fight for them when you lose them. And this program only works because I have the generosity of attorneys in the community who give of their time. I'm a new grad. I've been out for now about 1.5 years, and I have the Wayne alumni who are just phenomenal people. And Mike Witzke, who is a Wayne alumni, was kind enough to volunteer for my program. He's been with my program for several months now. He's helps me immensely. I call him, I say, Mike, I've got this issue, and he gives me some great guidance, and then he also takes some cases on for us, and he was very willing to give his time this morning to you. Mike has been an estate planning attorney for many years. He's excellent, and I'm just thrilled that he's here today to share his wisdom. Thank you, Mike.
Great, thank you. Thank you. And this is one of the few chances you get to spend some time with an attorney and ask all the questions you want and not get a bill for it at the end of the session. So you want to take advantage of that. We are being recorded. If you want to ask a question and not have it be on the recording, if you just let us know, they will edit those questions out. Also, because you attended today, if you have some questions of maybe a more personal nature and you would like to sit down and go through things with me, we can do that and give you a half-an-hour review without any charge to go through your personal situation and have questions answered as well. So don't, as I said, as we go along, don't hesitate to ask questions. What this session today is about is really to understand the basics of estate planning. What is estate planning? How does it work? What are the documents that should be in an estate plan? I can kind of let you know what it costs to do the different types of planning that we're going to be talking about. And certainly it's an opportunity for you to ask any questions that you have about estate planning or the estate planning process itself. Okay? When we talk about estate planning, what we really are, sometimes people say, well, I have a will, is that estate planning? Is that not estate planning? Estate planning is an overall plan that deals not only with what would happen if you were to pass away, but also what would happen if you became incapacitated. So if you got sick and couldn't manage your affairs, part of a proper estate plan is having somebody named in advance who can step in and handle your affairs for you. So when we talk, about doing estate planning, we're not just talking about what happens if I die, but also what happens if I become incapacitated and can't manage my affairs myself. Having a plan in place that's going to cover both incapacity and at death. And so what we try to solve with the proper estate planning is first making sure that the right people end up with your property, they get it at the right time with whatever restrictions are appropriate, and that if you can't manage your affairs, the people you've chosen are managing them for you. So I can use myself as an example here. I'm married, I've got 3 sons at home. If my wife and I were both to pass away, we want our sons to benefit from our estate, but they range in age from 12 to 17, so they're not old enough to manage the property themselves. So our estate plan is set up that if we both are gone, the assets are held for them for their health, their education, their support, but they don't get a check to run off and do with what they please until they turn 25. And at 25, they can pull out 1/3 of what we left for them. At 30, they can pull out another 1/3. And then at 35, they have access to the whole thing. So that's a way that we've structured our estate plan so that our kids have access to the funds, but they just can't run off and buy a boat or a fancy car or something like that until they're old enough and they have some maturity and education to manage the assets themselves. Now, I have clients who have adult children, children who are in their 30s and 40s, and they still don't know how to manage money. And so those clients have also put some restrictions on it so things don't just flow to the child just in a lump sum when mom and dad die. The key to this is that you can structure your plan however you want. Also, another thing that the estate plan will allow you to do is protect the assets that you're leaving to your children. More and more of the clients that we work with today are concerned that their children might get sued, they might get divorced, they may have some tax problems, and they want to make sure that whatever they leave them as an inheritance could be protected from their children's creditors and ex-spouses and whoever else might be out there trying to get that money. A good estate plan can do that. It can protect your children not only from themselves, but from others who may be trying to come in and try to get their hands on what you might leave them. So that's that control feature. The first part of a good estate plan gives you control. Who's going to get your estate? When are they going to get it? How are they going to get it? And who's going to manage things for you if you're not able to manage them yourself? The second goal that we typically have in the estate planning process is to stay out of the courts. And here, we're primarily concerned about probate court, right? And I think when most people hear the term probate court, they think about somebody dying. And certainly your family could end up in probate court at your death, but you can also end up in probate court during your life. If you or your spouse were to become incapacitated, often a family member has to go to probate court to get control of your affairs. So as I was driving downtown this morning for this presentation, had I been cut off and rolled the car and been in a coma now this afternoon, if I don't have the proper documents, my wife may be forced to go to probate court to handle some of our affairs. Now, most people say, well, if you're married, don't you have most of your assets in joint names? And the answer is yes, we do. But there are some things that even if we have everything in joint names, my spouse wouldn't be able to do. One would be filing a tax return. So if it's April 15th, my wife and I file a joint tax return. We're both required to sign when that return gets filed. If I'm sitting in a coma somewhere, I'm not going to be able to sign. My wife might be forced to go to probate court to get the authority to sign for me. I don't want that. I don't want her to have to go to probate court and get a conservator, have herself appointed my conservator, because that means typically she has to pay attorney fees, there are court fees, and then everything becomes public as to what she's doing with our affairs. So I want to make sure I've got something in place that says if I become incapacitated, my wife automatically can pay bills, can file tax returns, can start lawsuits, can do anything financially without having to go to probate court to get that authority. Also, medical decisions. And obviously, we're giving this presentation in a hospital. In today's environment, even a spouse or a close family member can have difficulty in getting access to medical information if you're incapacitated and giving direction. So everybody in this room should have a patient advocate designation. That's a medical power of attorney that gives someone else the authority to make medical decisions for you if you're incapacitated. So if I get in a car accident, I want to make sure my wife clearly has the authority to make decisions. And I've shared with her what my wishes are, and I have a document that says she has control, and it gives her the authority to even to make decisions about ending life support if there's no hope of recovery. So, making sure we avoid probate. If I didn't have that document in place, in many cases, family members have to go to probate court to become a guardian. And so that the guardian then can make the medical decisions for the person who's incapacitated. So we want to avoid that probate court during life by having powers of attorney in place so that if we become incapacitated, our family doesn't have to go to probate court to get control. Then at death, your family can end up in probate court as well, but that can be avoided. Not all assets pass through probate. When a person dies, really there are three ways that the assets can pass. The first way is by joint ownership, okay? So if I have something in joint names with you and I die, in many cases, at my death, that just passes to you as the surviving joint owner. Now, a lot of people use joint ownership as a way to plan their estate. They said, well, when my mom and dad died, they put everything in joint names with the kids, and nothing went through probate. It worked out wonderful. I caution you about using joint ownership as a way to plan your estate. The problem is if you put your children joint on an account or your siblings or somebody else, what you do is you give them an interest in that account. And now if that child gets sued or gets divorced or goes bankrupt, their creditors could get an interest in the account. And I've seen this in multiple cases over the course of my career. When I was a very young attorney, I had a client, very nice woman, she came in, and she had put her son joint on her bank account. And she explained to me that she did this because she wanted to make sure that if she got sick, her son could come in and pay her bills and take care of her and do all those things that needed to be done. Well, the problem is her son had a business, and this business went under, and when it did, he got sued by a number of people. Now, if somebody sues you and they win, they get what's called a judgment. And then their attorney can send a letter out to all the local banks that says, you know, this person owes my client money, and bank, if you've got any accounts with their name on it, you're required to pay that money to me. Well, guess what? Mom's bank got one of these letters from son's, creditors. The bank in this instance looked at the account, saw it was joint with mom, so they cut it in half, and they sent half of mom's money off to the son's creditor. Now, mom could hire us, as lawyers to go in and argue with the judge that, look, judge, this wasn't son's money, it was mom's money. Son was put on the account for convenience. He never contributed anything to that account. And we may be successful in paying, getting that money back. But is it going to go back into mom's account? No. Anybody want to guess whose account it's going to go in? My account. See, there's somebody who's had an attorney before. Yeah, the legal fees for us to have recovered that money for mom could have easily exceeded what she lost. So be very careful about using joint accounts as a way to pass assets, because it does subject those accounts to the creditors of the people that are joint on there with you. Another problem with joint accounts is that not all joint accounts are the same. When you put something in joint name with someone else, you can do it as joint tenants with rights of survivorship, or you can do it as tenants in common. Now, if you and I own a piece of property as joint tenants with rights of survivorship and I die, at my death, that property becomes yours 100%. It does not go to probate. As I said, it passes to you directly as the surviving joint owner. But there is also another way that property can be titled jointly, and that's as tenants in common. So if you and I own a piece of property as tenants in common and I die, my half interest in the property does not go to you as the surviving joint owner. It actually goes to my heirs under the terms of my will. Big difference. And I had a client come in one time. She was very upset. She had lost her husband. She had a bunch of mutual funds and joint names with her husband. And one of the mutual fund companies was refusing to put the account into her name alone. So she came in to see me to find out what was going on. And as soon as she showed me the statement, I saw the problem. The statement said, John Smith and Susan Smith, tenants in common. Well, those three words on the statement required that that account, now the half interest in it, go to probate to get it put into her name. Because her husband died, it was tenants in common with her husband, and so his half interest in the account had to go through probate to get to her. So you got to be careful. And if you have a deed with somebody, for a piece of real estate, if it doesn't say one way or the other, the default is that you're tenants in common. So it's very important when you're dealing with joint property that you understand how that property is titled. So be careful about using joint property. The other thing that we see a lot, and this causes a lot of problems, is where you have a situation where mom has 3 kids. And we talk to mom and she says, well, my daughter is local, and so I put everything in joint names with her, and she knows that when I die, she's to split that with her brothers and sisters, right? Well, I hear that and start thinking maybe I will be able to put 3 kids through college, because I can tell you it often doesn't happen. And what happens is that mom dies, and son, flies in from California for the funeral, and he's got a copy of his mother's will on his lap that says everything is to be split equally between son and daughter. Well, he gets here and he finds out that, lo and behold, mom had put everything in joint names with the daughter. So the good news is nothing goes through probate, because it's all passing by joint ownership. The bad news is that mom's will only governs the property that passes through probate. So if nothing is passing through probate, guess what? Daughter gets everything and son gets nothing. And is that what mom wanted? Probably not. But if we call daughter and say, hey, you know what? Mom's will says to split everything 50-50. What's your plan? Very often we hear, well, my plan is that I was the one here taking care of mom. I took her to the grocery store, I took her to the doctor, I cleaned her house, I did everything for her, and mom put me on those accounts for a reason. She wanted me to have that money, and it's mine. And the answer is, it is hers. Once mom died, if it was joint tenants with rights of survivorship, daughter gets it all. The will doesn't apply. So one thing that if you only remember one thing I say tonight, today, remember this, which is that wills are subject to probate court. Probate court is where a will is deemed valid, and that's where a will gets administered. If you have your assets passing outside of probate by joint ownership or maybe by beneficiary designation or through a trust, then those assets are not going to be governed by your will. So joint ownership is a way that a lot of people plan their estates. I caution you, if you're one of those, because of the risk of creditors, because of the issues with how that property is set up, you got to be very careful about using joint ownership. The second way that property can pass at death is by contract. And so an example of that would be using beneficiary designations. So if you've got a life insurance policy, if you've got an annuity, if you've got an IRA or a 401k, on those types of plans, you can name a beneficiary. At your death, the company pays directly to the beneficiary you've named. That property does not pass through probate, so it's a direct transfer to whoever you've got named. Also, many financial accounts now allow you to put a payable on death or a transfer on death designation on that account. Again, at your death, the financial institution then will just write a check to the person you've named. That money does not go through probate. So it's a very quick and easy way to pass the money. The downside is that there's no way to put any strings on it. So if you've got minor children like I do, or you've got a child who's a spendthrift, or maybe a child who's got some creditor problems, if you've got them named as the beneficiary, as soon as they receive that money, their creditors can get it. The other way that kind of by contract property can pass is through a trust. And so at the end of today, I'll talk a little bit about trusts and how they can be used to pass assets. Trusts are becoming more and more a popular way to have people pass their assets at death because a trust will avoid probate when you die and will allow you to put strings on how the money gets passed, name who should be in charge of things, and gives you the control you want, but keeps things out of the probate court. All right? So one way that property can pass is through joint ownership. We talked about that. A second way is through a contract, like a beneficiary designation or a trust. And then the third way, or the final way that property passes at death, is through the probate court. All right? And so sometimes people say, and I've had clients come to me and say, well, Mike, you know what? I've done a will. My will says where everything goes. Why would anybody have to go to probate court? Well, the answer is that the only way that these financial institutions and the places where you have your money know whether or not that's the valid will, or that's the right will, is if the probate court approves it. So I'll give you an example. Let's say that I die, and I've got an account at the bank with $40,000 in it. Just at a bank account. It's got $40,000 in it. I have a will. My will says at death, everything goes to my wife. All right? So my wife goes to the bank. She's got my death certificate. She's got my will. She says, unfortunately, my husband died. Here's his death certificate. Here's his will. His will says I get everything. Bank, I'd like to get the money. Now, is the bank going to give her the money? No. They're going to say, well, we're sorry, Mrs. Witzke, but we don't know if that's the valid will. For us to... Yeah, the name's on it. My name is on it. That's it. And it has my wife's name as both the person to be in charge, the executor or personal representative, and the person who's to receive everything. So it's got all that information, and she's got my... access to that account, would it still be that way? Now, if she was joint on the account, it would not be that way, because now it would pass to her as the surviving joint owner. In this example, I'm the only one on the account. So there's nobody else on the account but me. So she goes to the bank and says, well, what do I need? And they tell her, well, you'll need an order from the court telling us that that's the proper will and you're the proper person to be in charge. Which is great.
Can you set it up with the bank that you bank with to make sure that, say, your wife gets what?
Yes. So there's two ways that you can, there's probably three ways you could do that. One way would be to set it up where she's a joint owner on the account, which is not the same as being a signer on the account. Many people will say, I want to have my son be able to write checks on this account for me, and they add them as an authorized signer. Well, at your death, that authorization goes away. And so now the child can't write checks anymore. But if they're an owner on the account, your spouse would be able to get access to it. A second way would be you can put a payable on death designation on the account so that at your death, the insurance or the bank is instructed to write a check to the person you've named, which could be your spouse. The third way is that you could create a trust and have your account owned by your trust. Then if your wife walks in as the successor trustee under the trust, she doesn't have to go to the court. All right? So, but we didn't do any of that. It's still just in my name. So now what does my wife have to do? She has to go to the probate court, and she takes it and she says, the bank is telling me I need to have you tell me if this is a valid will. She says, I certainly hope so. My husband was an estate planning attorney, but take a look. And so the probate court then takes the will and says, yep, you're in luck, Mrs. Witzke. This is a valid will. Okay, and they would say, we're gonna take it and admit it to the probate court. And now they tell her she's got a couple of things that she has to do. Number one, she has to publish notice of my death, and then she has to wait 4 months for creditors to file claims. And then number two, she has to fill out an inventory listing the assets that are passing through probate and get that submitted to the probate court so they can charge an inventory fee. They charge a percentage of the assets that are in probate as their fee. All right? But so now you've got this probate process that's started that's going to take, at a minimum, 6 months in Michigan, and most probates take about a year from start to finish to get wrapped up. Had I done one of those things, had I put her joint on the account, had I named her as a payable on death designee, or had I put that account in my trust, all of that would have been avoided. It avoid probate. But people often say, well, why would you go to probate if you've got a will? You go to probate because the different places where the money is, they require you to go to probate to get the authority to get access to those funds.
Unless it's structured right.
Unless it's structured right. And that's why it's important, to sit down with somebody and go through how you've got your accounts titled, who are your beneficiaries on different things, to make sure that everything is set up properly so that if you get sick or you pass away, the assets are not going to pass through probate court. Probate, it's not as bad as it used to be, but in most cases, if we can avoid it, which you can by just setting up your affairs properly, you're going to want to do that.
Now, how would that work if you had property in one name? Let's say property's in my name.
Mm-hmm.
How would that work?
So you're talking about like a real estate, like a house or a...
Yeah.
Yeah. Okay. So, with real estate, for that, you can't put a beneficiary on real estate. So you would add your spouse to the property by using a deed. So if you bought a piece of property when you were single, let's say, and so it's just in your name, now you get married and we want to add your spouse to the property, then what we would do is we would do a deed from you back to you and your spouse. So now both of you are on the title.
Would that be considered a quitclaim?
You could use a quitclaim deed or a warranty deed. It depends on how you acquired the property. But yeah. So those are two types of deeds that would put somebody else's name on the property. And then you just need to make sure that it's done properly so that at your death, it's not, so you don't have to pay any tax. It doesn't uncap the property. But we also want to make sure that it's done properly so that it's with rights of survivorship and it's not set up to be tenants in common. Because I've had clients who said, all I need to do is quitclaim deed it to my son, and they do it in the wrong way, and then they still end up in probate. So you need to be careful with that. All right. So probate avoidance is another reason why we do estate planning, to make sure that things don't end up in probate if we get sick or we pass away. And then the last thing that we need to be careful about is taxes. And the types of taxes that we're worried about in estate planning, there's two. One is income tax. We're worried about income tax on any retirement accounts that we might have. So if you've got an IRA or a 401k or an annuity where money has grown tax deferred, when that money gets paid out, someone will have to pay income tax on it, whether it's you in retirement or your spouse after your death or perhaps your children after you're both gone. We want to make sure that that IRA is set up in a way to minimize that income tax. All right? The other tax that we have to be careful about is estate tax. Estate tax is sometimes called the death tax. It's a federal tax that applies to what's in your estate once your estate gets over a certain threshold. Now, estate tax hasn't been much of a worry for us lately because they've raised that threshold to $5 million. So if your estate's under $5 million, as most people's is, there is no estate tax you have to worry about. Whether you have an estate plan or not, if you're under $5 million this year, there's no estate tax. The problem we have is that number, that threshold number, keeps moving. And at the end of this year, that $5 million threshold is set to expire. And if Congress doesn't change the law, next year, in 2013, the estate tax threshold will be $1 million. All Okay? So again, still a big number, but if you've got life insurance, like I said, I've got 3 boys at home. My wife's a stay-at-home mom, so I've got about $3 million of life insurance. If I die and they lower the exemption to $1 million, that life insurance puts me over the limit. Life insurance, even though it passes to your beneficiaries income tax-free, is part of your estate and so can be subject to estate tax. So we need to make sure that we have to look at all of our assets, our life insurance, whether we've bought it on our own or whether our employer provides it, our retirement accounts, our real estate, all that, we add it all together, and if we're at or above $1 million, we have to be aware that that estate tax could apply to us next year, and there are certain things in the estate planning process we can do to help you avoid any estate taxes being paid. All right? But stay tuned. My guess is that we are going to go to 1 million, but then Congress is going to come in and change it to some other number. But what number that is, I'm not sure. But it is something to be careful of, because once the estate tax applies, next year the top estate tax rate is 55%. So once you go over that 1 million, so if, let's say all I own is $3 million of life insurance, and my wife and I die and we leave it to my 3 boys, you'd think they'd each get $1 million, right? No. There's $3 million in life insurance. $1 million of it goes to them tax-free. The balance, the other $2 million though, would be subject to a 55% tax next year. So that means they're going to end up with less than $2 million out of the $3 million that I bought. They'll have a little bit more than $1 million in estate taxes that would be due. Now, there are ways we can plan to avoid that, but again, that just shows you how important it is to pay attention to where that threshold is, because once you go over, the tax can be really, really dramatic. So again, our primary goals with estate planning are to give us control, who gets it, when they get it, how they get it, making sure that we avoid the probate court, both if we get sick and at our death, and then finally to make sure that we minimize any taxes that might be paid in our estate plan. So what documents are in a good estate plan? What documents should people have? Well, the first document is a document that deals with incapacity. And I'll start with this because we're in a hospital, and that is a patient advocate designation. A patient advocate designation names someone to be able to make medical decisions for you if you can't make those decisions yourself. So everybody here should have a patient advocate designation naming 1 or 2 people. So in mine, I name my wife as my primary person, but then I've got my sister and my brother as alternates to her, so that if we're both in an accident together, there's someone who can step in and make those decisions without having to go to probate court to get the authority through a guardianship. And a patient advocate designation really does 3 things. Number 1, it spells out who can make medical decisions for you if you can't. Number 2, it allows you to spell out what are your wishes regarding life support if there's no hope of recovery. Many of you probably remember the case from Florida, the Terry Schiavo case. Terry was the woman who was in that kind of persistent vegetative state. Her husband wanted to take her off life support. Her parents wanted to keep her on. And that went through the courts in Florida. The legislature got involved. I think even Congress got involved at the end. Well, in Michigan, we had our Terry Schiavo case even prior to that. We had a gentleman by the name of Michael Martin. I think was involved in some type of accident. Again, was rendered in kind of a vegetative state. His wife said that they had talked about this prior to the accident. He always said he didn't want to be kept alive that way. She wanted to take him off life support. Mr. Martin's sister, though, and mother disagreed with the wife, and they sued her and the hospital to prevent the life support from being discontinued. And the Martin case went all the way up to the Michigan Supreme Court, and the Michigan Supreme Court said that if we don't know what, if we don't have exact evidence of what he wanted, we had her testimony, we had all the things, but we didn't have his wishes spelled out clearly, we have to presume that he would want to be kept alive. So Michael Martin was kept on life support in this instance. The key to that case, though, is that we all have the right to choose. If there are circumstances where we wouldn't want to be put on a feeding tube or a ventilator or respirator, we can spell that out in our patient advocate designation and give somebody legal authority to make that decision. So again, very important that we all have that patient advocate and have thought through that. So if our family is ever faced with that decision, they have our instructions as to what is appropriate in terms of treatment going forward. The last piece of the patient advocate designation is a privacy release. Any of you who are here at the hospital are probably familiar with the medical privacy laws now we have in the United States. Every time we go to the doctor, we're asked to sign a release form. That's part of a law called HIPAA. HIPAA is the Health Insurance Portability and Accountability Act. And one of the things that HIPAA says is that doctors cannot share your medical information with anyone unless you've given them consent to do so. So part of that patient advocate designation has to be this HIPAA privacy release that says, doctor, hospital, if this person is acting as my patient advocate designation, you can share with them my medical information so that they can make informed decisions about my care. So the patient advocate designation and HIPAA release, that's the first document that everybody should have. The second document is a durable power of attorney. And the durable power of attorney is a document set up to give someone authority over your financial affairs if you're incapacitated. So if you get sick or get in an accident, this gives someone else the power to pay bills, file taxes, start lawsuits, do anything financially for you without having to go to probate court to get a conservatorship. All right? So the durable power of attorney, very important as a document to make sure that somebody else can handle your finances if you can't. Without that, and if it's tax time or we have to sell some real estate or we have to make a financial decision, pay bills, sign a check that you received, we're going to be forced to go to probate court and deal with a conservatorship. That's what that durable power of attorney can avoid. One thing that I also want to point out, if you have college-age children, I always recommend to clients that patient advocate designation especially, and in some cases a durable power of attorney, are very important for college-age children. There's nothing worse than your child being off at college, getting in an accident, getting sick, going into the hospital, and you calling the hospital saying what's going on, and them telling you, well, do we have a HIPAA release on file here? Otherwise, we can't tell you what's going on with your child. And there the child is away from home, at college, they're sick, they're injured, and the parents have no information. So that child, when they go off to college, should sign a patient advocate designation giving mom and dad the authority to make medical decisions for them and to get access to their medical information. All right? So the patient advocate designation, HIPAA release, and durable power of attorney are 3 documents. The next document is a will. All right? Everyone should have a will. Even if you have a trust, you would still do a will. Now, there are a couple things that a will does. Number one, a will is where you name guardians for minor children. So I've got 3 boys, all under age 18. I have a will that says who would raise those children if my wife and I were unable to do it ourselves because of either incapacity or death. Okay? So the will is where you would name guardians for minor children. Now, if all you have is a will and you don't have a trust, your will would also name who gets your property, how they get it, those sorts of things. The downside of the will, though, is that it is subject to probate. And so many people today are also, and along with their will, are doing a revocable living trust. And a revocable living trust is really kind of like a private will. It allows you to set up your affairs, say who's going to be in charge of things if you get sick or pass away, lay out clearly who gets your property, how they get it, when they get it. All that can be set forth in the will, or excuse me, in the trust, without the probate court having to supervise it or get involved. So I have a revocable living trust. As I said, in my trust, if something happens to me, my wife takes over and manages the trust. She's also the beneficiary along with my kids, so she manages it and can kind of keep things going without having to go to court. If my wife dies, the trust goes just to my children, and I've got my sister who comes in as the trustee. She manages the trust for my kids, pays for whatever they need, their education, their support, their clothes, all that. And then as my kids get older, they can come to their aunt, my sister, and withdraw funds. So at 25, they can withdraw a third of their share. At 30, they can withdraw another third. And at 35, they get access to the whole thing. Now, those were just ages that my wife and I thought were appropriate ages to get distributions. As I get older, that age 25 seems to keep getting younger, and so we're thinking now about changing that and maybe pushing it out. Not because our kids are bad kids, but because we want to make sure that that money is there for them. And I don't want them, to fall in love at 23 and marry some gal and find out it's not the right person at 28, being in a knockdown, drag-out divorce, and them having a bunch of money sitting in their lap that now is going to get divided up. Instead, it can stay in the trust as long as we want it. We've got some clients whose trusts never distribute out. The kids have access to it. At some point, the kids can even become the trustee of their share. But it never comes out of the trust and goes in the child's name where it could be subject to their creditors. All right? I have a client who set up their trust that said, they have a child that said, listen, I'm not sure they're ever going to be a productive member of society, and I don't want to pay for them to just go off and do what they want to do. And so this client's trust says that the child gets a distribution out of the trust each year equal to his W-2 income. Okay? So if the son decides he's going to surf for a living, I'm not sure what that pays these days, but he's probably not going to see a lot of money from dad's trust. On the other hand, if son gets a good job and he's making $50,000, $60,000 a year, dad's trust will match that each year. So you can set up however you want. I've got clients who have children with special needs. Those children are never going to be able to live independently. And those children are going to need to be, typically get some support from Medicaid, SSDI, other forms of state and federal support programs that are needs-based. And so if mom and dad pass away and they leave that money to that special needs child, if the money goes in the child's name, it could disqualify the child from any assistance that they're receiving. So we will create a special needs trust inside of mom and dad's trust that if whatever money they leave to the child can supplement what the child is receiving from Medicaid and other assistance that they're, but not to throw them out of it or replace it. So all of this can be done. There's, the beauty of a revocable living trust is we can draft it to meet whatever needs you might have. And you might have various assets that you want to go to specific people. You may want to have some assets that go outright and other assets that are held in trust. All of that can be covered under that trust. So revocable living trusts are very flexible. They keep us out of probate. They give us control. And because of all that, have become a very popular way for people to plan their estates these days. All right? Now, once you have that trust set up, it's important that you fund the trust. So what does that mean? What funding of the trust means is that you connect your assets to the trust. You can create this great living trust that says, I want everything to be controlled for my kids, and I want my spouse and then my brother to be in charge if I'm not there, if she's not there, and all this gets set up. But if you don't connect your assets to the trust isn't going to control them. So again, if you've got that bank account, now instead of it being in the name of Michael Witzke, the account's going to be in the name of Michael Witzke, the trustee of the Michael Witzke Trust. So now if I die, my wife becomes the trustee of the Michael Witzke Trust. She can go to the bank and she's in charge right away. Doesn't have to go to court. It's automatic. And if my wife and I both pass away, my sister becomes the trustee. She has access to what's in that account and can use it for the benefit of my children. But things have to be connected. So if I've got a life insurance policy, I can name my trust as the beneficiary. Now if I die, the insurance company writes a check to the trustee of the trust and it goes right in there and it's protected. Same thing with a retirement plan like an IRA or a 401k. We can name the trust as the beneficiary of that. If I've got a piece of real estate, I can set it up so that at my death, the real estate drops into the trust. But we need to connect things to the trust so that the trust is able to control how things pass. Now, if I do a trust, do I still need a will? The answer is yes. I need a will for two reasons. One, because I still have minor children, and I'm going to name the guardians for the children if something happens to my wife and I in my will. But second, we also do a will with a trust as a safety net, that if something did end up in probate at my death, we have a way to get it out. So if we've done a revocable living trust, the type of will we do is special. It's what's called a pour-over will. And what it does is it acts as a safety net that if something did end up in probate at my death, the will pour it over, or pay it over, into my trust. And then my trust would be where that asset would be held and administered and distributed. So why would something end up in probate if I've gone through the effort of setting up a trust? Well, there's two ways that could happen. The first would be I just didn't get something connected to my trust before I passed away. So I had a CD at the bank and I just forgot to get it connected to the trust. I passed away. It was just in my name. There was no beneficiary. That CD would end up in probate, but the will would be there to catch it and to pay it to the trust. The second way that something could end up in probate if I have a trust is if I was killed in an accident and my family sued whoever was responsible for my death. So an example there would be the guy that dies in a plane crash and his family sues the airline. Some of the money that the airline would pay out would be paid to the estate of the person who died in the plane crash. So we could do everything right. Set up a trust, get all of your assets connected to the trust, and then you were to pass away and there's some kind of lawsuit surrounding your death and money comes into your estate, the will would be there to catch that money and to pay that to the trust as well. All right? So a good estate plan is going to consist of a number of different documents. There is the medical power of attorney, there's the HIPAA medical privacy release, the durable power of attorney for financial affairs, there's going to be a will, and then there's potentially also going to be a revocable living trust. All of that together makes up the estate plan to make sure that we have control over where our property is going and who's going to manage it if we can't, keep us out of probate court, both if we get sick and we pass away, And the trust, if we have a tax situation, if we're worried about estate taxes, the trust can be drafted in a way to increase what can be passed to our children without any estate taxes being paid. All right? Questions on any of that?
Mike, I know a lot of times when clients hear all this, they get really nervous because they think this is going to be really, really expensive.
Mhm.
You had talked a little bit about maybe kind of giving some type of estimate or ballpark so people have some sense of what to expect. So if they do
Sure.
go shopping for an attorney,
Right.
to know how, would that be an appropriate amount to
Yeah. So, the question is kind of what does it cost to do all of this? And like all good lawyers, the answer is it depends. Okay. So, we learned that's one of the first things we learned in law schools. That's the best answer to just about any question. Most lawyers who do this for a living, and I would recommend to anybody who's here today or who is watching the tape, that you use a lawyer that this is what they do primarily. The guy that does slip and fall on Monday, divorce on Tuesday, and yeah, I've got a form for a will somewhere, I can do that for you on Wednesday. I'd be careful of that. These laws are changing on an annual basis. The laws change, and you really need to have someone who understands things. Most attorneys who do this as the core of their practice are going to charge a flat fee to do these types of services. And that flat fee is going to vary based upon the complexity of your plan. But for a single person to do this type of planning where you have all those documents we talked about and we include the trust in that, for a single person, you're typically going to spend between $1,000 to $2,000 to have all this done. If you're a married couple, it could be anything from $1,500 up to $4,000 to do all this. Now, to get to $4,000, typically it's a second marriage, or there's got a business involved, or maybe we have a special needs child. But that's why, in our office, and I think most good estate planning attorneys are going to sit down with you in the initial consultation without a fee, go through your situation, and then at the end of that initial consultation can say, okay, based upon what you've told me and what needs to be done in your circumstance, this would be the fee. And then you can decide whether or not you want to go forward without any obligation. Okay. Other questions? So I've either confused you to the point where you don't know which end is up, or I was so clear and concise that we covered everything.
You know your subject very well.
Well, he's a plan. He's actually a client of mine, so he's here just to give me an encouraging smile when I look over, right?
You don't need it.
Witzke, you did mention conservator and guardian, and I was just wondering if you could distinguish a little bit.
Yeah. So the question is can I talk about a little bit about a conservator and a guardian? Guardians and conservators are appointed by the probate court for somebody who can't manage their own affairs. So that could be a minor. So if you've got someone under the age of 18 who's inherited money, or maybe has received money as part of a judgment if they were involved in an accident or something like that, because they're under age 18, they are not able to manage that money themselves. Often a guardian or a conservator would be appointed, or it could be an incapacitated adult. Someone who is incapacitated either because, again, an accident, an illness, or perhaps they have some type of disability that causes incapacity where they're not able to manage their own affairs. A guardian is appointed control over the person. So the guardian, you kind of compare it to kind of a patient advocate designation. A guardian is making decisions on placement, where the person lives, what kind of treatment they receive. They oversee the person's kind of daily life and that where they are and what they're doing. A conservator has control over the money. So the conservator is named where we have an income stream coming in, or they've got a pool of assets that needs to be managed. The conservator is appointed by the probate court to manage the money. So the guardian manages the person, the conservator manages the money. All right? So you can have a guardian and conservator appointed for you. It could be the same person, or it could be separate persons. Just depends on the situation. And that's a probate process. So somebody goes into the probate court and asks to have someone appointed. So that could be a parent, it could be a facility, it could be a hospital, where decisions have to be made for somebody who's incapacitated, and we're looking for somebody to be able to have the legal authority to make those decisions. So somebody goes into the probate court, they petition, the probate court appoints the guardian or conservator, and then the guardian or conservator reports back to the probate court, at least annually, as to what they're doing. Now, I talked about probate at death, And if it's fairly straightforward, it takes anywhere from about 6 months to a year typically. Now, if there's a contest or if there's fights over things, it can go on. Or if we have real estate that can't be sold, it can go on for years. Guardianships and conservatorships go on for as long as that person remains incapacitated. So if we go back to that example I gave at the very beginning where I was in a car accident, I have a closed head injury, and I'm incapacitated, if I don't have a financial and medical power of attorney and my wife has to go to court to become my guardian and conservator, now that guardianship and conservatorship, that probate process goes on potentially for the rest of my life. So you could have a 20 or 30-year probate that goes on, and every year somebody has to go to probate court and report and pay attorney fees, potentially in court fees. So that's why these documents are so important, that if somebody gets sick, we don't have to worry about that living probate process that could go on for years and years and years.
And I think you've made it really clear, Mike, that by doing the financial power of attorney and the durable power of attorney for healthcare or patient advocate, you get to pick
Right.
who those people are versus somebody walking into a probate court saying, I want to do this.
Yeah, and that's very important to many people who have, who have certain members of their family that they want to make sure are not the ones chosen. I've had clients many times tell me, my brother is a derelict. He doesn't pay his bills. He kicks his dog. He's abusive. But he puts a suit on and goes into court. He can talk, and you would think he was, the president of the bank. And I'm afraid he's going to walk in there and try to get custody of my kids because they're attached to my money, and I don't want that to happen. And so that's what, by having proper documentation in place, you get to choose who fills those roles, not a judge who really doesn't know your family or the dynamic or your values or what the kinds of things that you want to have enforced in your family arrangements. And this is something that nobody likes to think about. Nobody wants to think about incapacity, death, dying, not being there for your kids and all those things. That's what causes probably the biggest problem. I mean, the biggest problem is not the probate court or the Internal Revenue Service. The biggest problem is us. It's procrastination where people wait and don't get these things done. And so I do really encourage all of you, whether it's with me or somebody else, to sit down with an attorney and make sure that your affairs, if you have an estate plan, have it reviewed. That's another thing that I get asked a lot is, I did an estate plan. I did it 10 years ago. Aren't I done? The answer is no. You really need to go back every few years to make sure that it's up to date with changes in the law, it's up to date with changes in your family situation, and that the assets are titled properly. That we've checked the beneficiary designations. We just had a client who passed away, and they had an IRA. We went to check with the IRA company who the beneficiaries are, and they said, we don't have a beneficiary on record. That's terrible, because now we're really stuck as to how that money has to come out of that IRA a lot faster, and we're going to have to pay the income tax on it in a way that we don't want to. We really wanted to stretch the IRA payout over a long period. We're not going to be able to do that because apparently either there was not an IRA beneficiary designation turned in, which we doubt, or they lost it. And what we see now with a lot of these banks, somebody goes to their local corner bank and they open an IRA. That bank then gets bought out by another bank and then another bank, and now it's 10 years later and there's been 3 different names on that bank all along, and we go to find the beneficiary designation and it's not there. They've lost it in all that mergers and acquisitions and all those things. So it's very important on a regular basis you check who your beneficiaries are and you make sure that there's proper records and that those are up to date. Also, we see, and I've seen, couples been divorced for 15 years, and the husband dies, and he still has his ex-wife from 15 years ago named as the beneficiary on the life insurance. And is that what he wanted? I don't know. But the kids typically disagree. They say, no, that's not what he wanted. He wanted it to go to us now because they haven't talked in 15 years. Why would he leave it to her? So checking those beneficiary designations, checking over your documents, just because we did it once doesn't mean we can put it on the shelf and forget about it. It needs to be reviewed on a regular basis.
On a bank account, it's nice to have somebody on there besides myself in the event that I can't get there.
Right.
Well, how is that handled? Like I know I have my daughter on my bank account.
Right. So the question is, if I have a bank account and I just want someone else to be able to have access to it, you can put them on there as a signer, but not an owner. And if you have them on as a signer on the account, if you can't get there, they can write checks and make deposits and get access to the account. But if they're only a signer and not an owner, now if that daughter gets sued, gets divorced, goes bankrupt, her creditors can't reach the money. So
Her name is on there as
if it's on it as an owner, then it does expose that account to her creditors, and at your death, in most cases, she's going to be the owner of the money. That'll trump your will or your trust that you've got set up.
How should it be done?
Typically, it should be set up where she's just a signer on the account. She's not a co-owner of the account.
Then upon death, where does that money in the bank account go?
Well, then what you want to do is you either want to have it paid. You want to have it payable on death to your trust. So it goes into your trust, and then your trust distributes it out the way that your trust designates. It's just by setting it up at the bank to have it go pay to the trust at your death. Yeah, like a beneficiary designation. Okay.
Mike, are there, as far as putting somebody on as a signer,
Mm-hmm.
is there any limits to what they can sign a check for? So in other words, like let's say somebody wants to be on as a signer, but the thought was is that person was going to use that money in the account to take care of somebody.
Mm-hmm.
And let's say the daughter who's the signer starts writing checks for like her new car and things
Right.
like that. Is there any way to
You know, I mean, I had a client ask me about this the other day about could I put a dollar amount that she can't sign a check over $3,000 or something like that. Most of the banks are not going to allow you to do that. They don't monitor the checks. You know, it's all done electronically. So there's not somebody looking at the check and seeing what the amount is and that sort of thing. So the answer is no. You don't. If you don't trust them and you don't think you can, there's a concern about that, you shouldn't put them on the account.
And the other question is, let's say, for example, the person who's ill has a bank account of, let's say, $50,000,
Mhm.
and they do put somebody on as a joint owner.
Right.
When the creditor looks at that account, does the creditor see all $50,000 as belonging to either owner, or do they only have access to that?
So the question is, if I have a joint account with my son and there's $50,000 in that account and my son gets in a car accident, gets sued for $1 million, what's at risk? Half of or all of it? The true answer is if my son has the rights on the account to walk in and write a check for $50,000, that's what's at risk. So it's, in the case that we had, I think that where mom had it with son and mom, they garnished it for half. I think technically they could have garnished it for all, but they didn't. So the reality is if they have the right to write a check or withdraw the full amount, that's what the creditor could withdraw.
Thank you.
Yeah. So. All right. Any other questions? Well, I'll stick around. So if some of you have individual questions you want to address, I'll be here. And again, if any of you are interested in a one-on-one consultation with no charge or obligation, because you attended here, you certainly can take advantage of that. In the binder that or the packet that we left you, there is a blue page that's an evaluation. I would very much appreciate you taking the time to fill that out. It lets me know what I did well, what I didn't do so well. And then on that blue sheet, you can also note if you want to take advantage of the free consultation. Again, there isn't any obligation if you want to come in and take advantage of that, or any cost for that, but it is available to you if you're interested.
Thank you
Okay?
very much, Mike.
All right, thank you.